Senator. So I didn't know I was going over the bill too. So do you want me to kind of do my statement and the reason for this first, and then we can kind of go over that, or is that?
Yeah, briefly, the reason that you feel that the Attorney General feels this is an important subject that can't wait for legislation next year.
So we're talking about the disclosure of sexually explicit images without consent, which is known colloquially as the revenge pornography law. The typical scenario, but is not always the case, is that an intimate relationship has soured and consensual images or recordings made in happier times are now used by one of the parties to cause harm to the other by leaking these images intentionally on various media platforms or directly to friends, family, and places of work. Posting these images online is damaging to the reputations of victims and have negative lifelong effects, including mental health, destroying future relationships, and educational and employment opportunities. Further, victims can be threatened with future sexual assault, stalked, assaulted, or harassed, depending on what platforms the person has shared this information on, namely rape fantasy websites or other hardcore sexual forums seeking partners. The proposed language offers clarification regarding the digital reproduction that is already part of the revenge statute to include an image created or altered by digitization. This is in response to the proliferation and ease of access to AI or artificial modeling known as deep fakes. Deep fakes are synthetic media that has been digitally manipulated to replace one person's likeness convincingly with that of another. It was not hard to predict that this kind of reproduction would be possible, but this kind of image traditionally has not been sophisticated enough to fool anyone and was easily identifiable as changed or tampered with. Unfortunately, that has rapidly changed. Deepfake modeling software has become more accessible and the technology is very realistic. These deepfakes are now being weaponized by targeting identifiable people to inflict the same kind of harm as contemplated in the revenge statute. Although this new layer is even more concerning as the target has to contend with something of an image that never happened. Deepfakes allow the manipulation of an identifiable person in whatever scenario they wish. And when someone wishes targeted harm, you can only imagine the possibilities. You've heard the saying, a picture is worth 1,000 words, and that's the problem. Words like, that wasn't me in that picture, become a pale comparison to the image. It is like yelling in the wind, and reclaiming that image from the internet is exceedingly difficult, so this lives on. As with all technology, the law struggles to keep pace, which is why this clarification is needed. The proposed language tracks the New York statute regarding their revenge pornography law. They were a little ahead of the curve on this, which we are lucky to benefit from. This clarification only pertains to this specific crime and requires an intent. It does not, at this point, cover the mere possession or creation of such materials. It deals with the targeted dissemination of it to inflict harm on an identifiable person. This is meant to quickly address deep fakes as included in this particular statute so that we can address the specific harm that is being done now without delay. We certainly understand that there are more conversations to be had regarding emerging AI technology and the impact that it will have across many aspects of law. And we look forward to being a part of those conversations. This, however, is something that can be done now, and we hope that you will support victims today with this important clarification.
So just to be clear, this is only for either sexual or nude conduct. Doesn't include, for example, taking a picture of somebody falling and inserting somebody else in there to make it look like I fell.
No, it's only contemplated with the revenge pornography.
Sexual act.
Correct.
Okay. And I mean, this is all beyond my capability. I couldn't even Photoshop myself into a picture. Some movie star, but so people are able to do this.
So what's interesting with that?
Are there cases in Vermont where this is actually happening? That's, I guess, the question.
There could be. Right now, it would be, we think we could make an argument under the reproduction part of it, which is why we like the clarification. Bless you.
Thank you.
There are certainly, this technology is emerging and it's going quickly. I can't think of anything specifically in Vermont, but also there are 14 other, states attorneys, and it's just, the Attorney General's office. From our perspective, we have not seen this, but what we have seen is this wave across the country in dealing with these kinds of things. They're used in a lot of different places. The technology moves fast every day. Where you're saying that it would be very difficult to do this. There are apps now that make it very easy. That's the problem, is that you just insert a picture and all of a sudden it does everything that you wouldn't know how to do. And that makes the accessibility of this and the ease of it really disturbing. It's also an internet thing, so once it's disseminated, you can't really claw it back. Like a physical picture that you give, you can kind of take it back from everyone. This is the entire world that it opens it up to. So that is kind of where we're at, this nexus of it. Used to be very difficult to produce even anything like this. This was Hollywood stuff, CGI things. This is now done with phones and apps and things that are very accessible, and it's just going to keep growing.
Other questions, Senator?
We have an AI task force, yes?
There's an AI commission of some sort that I think is looking only at how the state deals with it and not necessarily the criminal implications or those kinds of other state laws.
Okay, so they have not weighed in or would not weigh in, doesn't really make.
I don't believe so. Maybe about how state employees deal with that or some kind of deep fake things, but I don't believe that there's anything that they're dealing with now.
Any other questions? Is there anybody who would like to comment on this proposal? Okay, we've got very limited time. Because I got to get to Judge Zone at 11.
Well, this is Rebecca Turner from the Defender General's office, for the record, and I will be very short. I just saw this proposal minutes ago, and what I'm hearing described is raising alarm bells that I want to put our concerns on to give some thoughtful response to it. I mean, the concerns in terms of anything when you're tweaking about that statute generally and images are into First Amendment considerations and what is changing these definitions. Prior bills, people from our office have come in to talk about what the changes in these definitions in these terms have meant, consistent with U.S. Supreme Court jurisprudence on First Amendment. So it may be, and I'm not prepared to counter whether or not this is consistent with New York statutes. What I am not prepared to do is to look at and dissect the actual language that is used. I don't even know the page number. I didn't hear.
It's much too loud out there.
I'll try to talk louder.
Yeah, but it's not your fault.
I just asked the session clerks.
Okay, thank you.
I didn't even catch the page number or the lines that was the proposal. So we were not given an advance copy.
Why don't we do this? Why don't we come back to this at a later time, since we're taking this bill up next week. Give you time to look at it and make further comment.
I appreciate it. Thank you.
Either you or the Defender General wants to comment. Schedule time for this next.
I'll reach out to that.
Yeah.
Thank you.
Thank you. We're gonna switch to, unless there's anybody else on this subject, we're gonna switch to the Baruch, so-called Baruch Amendment, which would be, and which is
trail cams.
trail cams that are directed at individuals
Do you guys have that
and
language?
evidently used for stalking.
It is in the draft, okay.
It's on page 55 of the most recent draft.
I only have
What?
up to 50 pages.
Yeah, I only have 50 pages. I don't know if I have the most recent
I think
draft.
we need our file on.
But I do have the
Which draft?
amendment.
Okay, I need to,
we don't have that draft.
let me
Yeah.
get it printed, but you should have the amendment.
Our draft contains 50 pages.
I do have
But
just a
given
standalone amendment.
that Judge Zone is on a time crunch, I'm gonna go to him and let him testify while we search for the language.
Well, good morning.
Judge Zone. Good morning.
So Tom Zone, Chief Superior Judge.
You're in a different place this morning.
I am. I'm at a symposium on child welfare in Philadelphia today and tomorrow. And so We're a traveling man this week.
Yes, sir.
So I've had an opportunity to review H 878, the two-page draft 1.1 411 2024, the Baruth Amendment, so-called. It addresses issues of surveillance. When I looked at this bill, the first question I had was in the on page 1 of 2, where it talks about line 7 through 10 about it says a person shall not place a camera or other surveillance device on any privately owned real property with the intent to conduct surveillance on the person or the property unless the person has obtained prior written consent from the property owner. The utilization of the word "the" in front of person makes it seem as though there's a specific person it's geared at, but it's unclear if that who that person would be. It seems as though to make it clearer, it would if you just deleted the person, it could say a person, or you could even delete the whole part about person and just say it with the intent to conduct surveillance on the property. If the intent
Judge
is,
Zone, I think we're going to pause for a quick second.
oh, sure.
We also don't have.
So I just lost hearing your sound for a moment.
All they care about is being a, this is ridiculous. We cannot hear because we have so much noise out in the hallway. And Sergeant at Arms doesn't give a damn about legislation. They only care about having a damn tourist spot.
Would it work better for me to try later at some point if it's quieter, or try to continue now?
It just quieted down.
Okay.
I
And
think
so,
my little tantrum caused a problem.
Right.
Jesus.
so when you look at the structure, I think it does become ambiguous where it has the phrase "the person." And again, you may wish to consider that if you went forward on this bill to just have it be surveillance on the property if that's the intent, because that would cover if it surveils any individual on the property seemingly. The statute also uses, it says, place a camera or other surveillance device. Is a cell phone a camera? And I point that out because the word camera might be something that is limiting if that's not the intent. So what you may really be looking for here is a device that is a recording device for audio or visual images, something like that. The statute then talks about take it down. It talks about with the intent to conduct surveillance, and this gets into issues of mens rea, and the definition of surveillance at the bottom of page 1 on line 19 says, with respect to an owner or occupant of privately owned real property, the observation again of the person with sufficient visual clarity to be able to obtain information about the person's identity, habits, conduct, movements, or whereabouts. Sufficient visual clarity is going to be, it's very subjective. If the intent is that you are trying to enact a bill that is simply going to say, you can't record on someone's property anything unless you have written permission, this adds a number of hurdles to that in terms of the mens rea. What is the intent? Are they intending to observe someone, or are they intending to observe deer or turkey for game cameras? And someone could say, well, my intent was to observe game cameras, and the fact that I observed someone who was on the property was not my intent. And so it really becomes a matter of what is the focus of the bill trying to get at, and can you get there without adding in requirements of the intent to get a single person, or is it intended to say, we just want to focus on if this is put there for going after one person? And then you might want to change the language of the person to a person to make it clear, because the person would indicate that we all know who we're talking about. And the statute doesn't lead into that in anywhere, in any of the sections. It then talks about Under surveillance device on page 2, it defines it to talk about being used to secretly observe the activities of another person for purpose of spying upon or invading the privacy of the person. So this seems to actually tie into what I was just talking about. In other words, it seems like, okay, the intent here is to really focus on the spying. And if that's the case, you would want to possibly redo some of the language up above to make it clearer instead of, again, having it say the person. But when you look at the words secretly and spying, they're not defined in the statute, which means generally when you don't have a statute defined language, we would use the dictionary definitions. And is that the intent? Could you just say hidden in there? And again, this gets to the intent. And for instance, you know, you could say for a surveillance device, language to the effect of surveillance device means a device hidden or obscured from plain view and which permits the observation of privately owned real property or the activities of another person in such a manner which invades the reasonable expectation of privacy on the property or of any person thereupon. Something like that would seem to get at what you're trying to talk about as opposed to using words like secretly and spying. And my final, I'm sorry, Senator.
Oh, no, go ahead with your final point, and then, because I have 2 questions about different sections, so go ahead and finish up, and then I'll ask.
My final comment is that this does not contain a law enforcement exception. Under Vermont law, we have a reasonable expectation of privacy in open fields if they're posted or individuals take steps to prevent others from entering upon them. There's a Supreme Court case named Kirchhoff that talks about that. There's also a case called State v. Costin. I believe it was from 1998. And basically what the Costin case was the police went in and saw a marijuana grow operation, and they went back on the property through a trail, which was located, the house was about 150 feet away or so from the marijuana, and they went there and they put in a camera. And the Supreme Court said because the owner did not take any steps to exclude the police from, or anyone for that matter, from coming onto the property, it was permissible under our Constitution to allow law enforcement to place that camera there to observe for law enforcement purposes. And this bill does not contain such an exception for legitimate law enforcement activities. And so, as written, this would basically say law enforcement would not be able to engage in behaviors that the Supreme Court has indicated would be permissible activities in accord with the Vermont Constitution.
Okay.
So I have 3 questions. I'm going to go backwards. The first one is in the type of law enforcement behavior that you're describing, would one need to get a warrant to do that, or can they just? Okay.
No, the Vermont Supreme Court differentiated between a situation where someone has no trespassing signs, fences, or has otherwise sought to exclude individuals. In those circumstances, the Supreme Court has ruled that you do have a reasonable expectation of privacy under Article 11 of our Constitution. In circumstances where there have been no steps taken to exclude the public, no signs, no fences, nothing, our court in the Costin case ruled that there is no reasonable expectation of privacy, so law enforcement would not need to obtain a warrant in that circumstance.
My other question, so I really liked your definition of surveillance device, and I'm wondering if you might have that in writing to send our way. So that made a lot more sense to me than the way it's worded here. And then my other question, I guess, is around the camera or other surveillance device. And I hear you that camera may be kind of narrow, but do you feel like other surveillance device sort of captures the things that camera might leave out?
Well, if surveillance device, a surveillance device as defined in what is currently in the statute and even in what I had come up with was really, as I understood it, was a device that you're secreting. You're hiding so people can't see. So I don't think if that's a surveillance device, that would cover cameras because, for instance, my iPhone is not a surveillance device, but if I stuck it there and hid it, it could be. And so it, I think that it could be cleaner, perhaps, is a way of saying it.
Thank you.
Other questions for Judge, Senator Sheen?
Thank you. I'm curious, Judge, about, well, thank you for your input on some of the suggestions here. I think they make sense, but I'm curious about the situation in which somebody sets up a trail cam and they have permission to set it up on, one piece of property, but at some point there's a boundary and then there's another piece of property and, maybe a house over there. And the person is intending to conduct surveillance, but, for hunting reasons. Do you think that with this language, they would be swept up under this or no?
Well, surveillance means on the second one with respect to privately owned real property, this talks about the observation of physical improvements with clarity to be able to determine unique identifying features about the property or information about its owners or occupants. And then up above when it talks about to obtain information about a person's identity, habits, conduct, movements, or whereabouts. So it would not necessarily seem to bring in the trail cams, but what it does do with that type of language is it really focuses on the intent. And so, for instance, someone could say, well, they could put up a trail cam with the intent actually to do what this statute is seeking to prohibit, but yet say, no, I was looking for deer. And so there's a difference between saying, if you are going to put up a trail cam, any type of surveillance on privately owned property, the policy is you need to have permission of the landowner. End of story. And so you don't delve into the question about what was the intent. That's a different policy than this bill. This bill is, by its terms, you have to really focus on what is someone doing there and why are they doing it? Are they doing it to monitor the property? Are they doing it to monitor an individual on that property? Does it have to, it would have to be a specific individual under this bill, not just any individuals who may come onto that property.
So you're suggesting that it would be up to the landowner to, unless they have permission from the landowner, then they can't do it.
That would be one policy. That's a different policy, but than this one that's being in the bill, because this one requires you to, the prosecutor state would have to establish elements of why were they doing it. If you went in a different direction.
The other night I was out on my deck at home, looking at the stars, which I do from time to time, believe it or not. And what appeared to be a drone started coming at me. Luckily, it was a star, but I thought it was a drone. It was low. It might have been a plane, actually, but it was low and it appeared to be a drone. Would that be covered under this? Because I think that's a way that people are surveilling other people unwittingly, or you don't know it. And I was thinking, my God, I have no defense against this drone. I mean, I don't have a shoot it down. I suppose I could if I went and got it.
Drones and the others.
So under the current definition of surveillance device, the question would be, most likely, is that secretly trying to observe the activities of someone? And if it's coming up and you can see it, it's probably not secret. And even the definition that I had I've already sent it on to Ben, by the way, even that language that I utilize talks about hidden. So that would not appear to be covered in a situation that you've just referenced, Senator, because it's not hidden, it's not secret, it's right out there in broad daylight coming in.
Well, what can I do?
You could come up with you could phrase the statute to say that you can't run a drone over someone's property with the intent to. I mean, in other words,
I don't think I can shoot a firearm in my neighborhood because I'm too close to other houses legally, but who's gonna know?
Reckless endangerment.
Senator, go ahead.
Yeah, so my concern, and Judge Dunne, you may not be able to answer this, but it comes from the sort of previous question around reasonable expectation of privacy and posting property and thinking about people who rent and may not be allowed to post the property, or people who, and so this bill would not protect them because they don't have a reasonable expectation of privacy because they're renters, not homeowners.
Renters absolutely have reasonable expectations of privacy. It's a fact-driven question in connection with what's called the curtilage of the house and what's outside the curtilage. And so it's not that you're the renter, you don't have a reasonable expectation of privacy. It is a matter of, well, let's look at the specific facts here in any
Okay.
given situation. So renters certainly do have reasonable expectations of privacy in the property that they rent. The question is, what are the limits of that? And
Okay.
that would be very fact dependent.
So
Okay.
I did find the drone section Eric pointed out to me, but the drone has to be under 100 feet. And I don't know how I judge whether the drone is 100 feet above me or more or less. I'm not that expert at it, and I don't have a laser to point to the drone and give me the exact height of the drone. So I'd take my chances of shooting it down.
Just regarding the 100 feet, this sort of estimation also happens with speed enforcement. Because you have to estimate the distance and estimate the speed of someone before, you're blocking them with the laser or the radar. And so, on the back of the ticket, you'll write, I estimated at approximately 1,000 feet, they were going 85 miles an hour. And then, you do the radar or the laser, it'll tell you 950 feet and they're going 84 miles an hour, and you write that down. And so that's where that estimation tends to come in, and it's what you present in court when you're.
Well, I mean, as we look at section 44, maybe we want to put appears to be less than 100 feet.
So can I just ask, is the estimation a way of saying you have reasonable suspicion to use why is the estimation still included if you have the laser?
Yeah, it is part of building reasonable suspicion, because generally you're not just randomly pointing your laser at everyone. If you see somebody flying down the interstate, you can estimate, oh, that person's definitely going 90. Use the laser, going 88, and you document.
Okay, makes sense.
Okay.
Could I add one?
Yes,
Just so the
please.
committee knows, and Judge Zoning knows too, the definition of surveillance device that you're referring to didn't come out of the blue. That's verbatim the definition of surveillance that's in the voyeurism test. Just so everybody knows.
From the voyeurism.
Yes.
Good. Judge, enjoy the rest of the conference. We'll
Thank
try
you.
not to bother you until next week.
I'm coming in next. I'm supposed to be in tomorrow, I believe, on
Okay.
H76. And I understand that the committee may have questions about a women's prison. Am I correct on that? That's not part of the bill, but I just wanted to make clear.
Yep, that's a corrections, miscellaneous corrections bill.
Okay.
All right.
I'll see you tomorrow morning.
See you tomorrow morning. Enjoy the rest of the day.
We'll try. Thank you. Have a good day.
You too. Our next witness is an impacted citizen from Essex, Jessica. Welcome, Jessica.
Hello. So I wrote a statement I'm just going to read. Good morning. My name is Jessica Dow. I live in Essex with my husband and 2 daughters. Thank you for inviting me to speak today. I would like to share my experience with trail cameras. In December of 2020, my husband and I decided to take our young daughters for a walk in our woods. It was Christmas break and the world was still mostly shut down from COVID, and our land felt like a safe place to entertain ourselves. We walked to a spot my children had named Crystal Waters, which was a small stream they like to play in and around. It was a place we frequently visit. After exploring there for a while, we decided to walk and explore deeper onto our property. This is when my husband noticed something strange on a tree. We were unsure of what it was, as we had never heard of trail cameras at this point, but it was obvious that it was some kind of camera. After some debate, we decided to remove the unmarked device from the tree since it was on our land. We brought it home and did some research on what it was and how it worked. We learned that this specific device was a cellular trail camera, and we eventually found pictures that it had taken of our family on its memory card and learned that these pictures were instantly texted to the owner's phone. I was extremely upset. This felt like such a violation of our privacy. Early on, as a mother, I decided I was not going to post my daughter's pictures online and had worked hard to keep their childhood photos private. This cellular camera was placed in my backyard without my consent and took photos of my family in a place where we thought we were protected and had privacy. We placed a few calls and a game warden came out to our land. The warden found 2 additional unmarked cameras, cellular trail cameras on our property and an unmarked tree stand facing our land just over the boundary on our neighbor's property. The warden was able to figure out who the owner of the camera was after speaking with a neighbor. The warden took the cellular trail camera from us and gave it back to the owner. The warden also told us there were no laws or regulations against placing these cameras on private land. I am here today to encourage you all to consider regulations on this type of device. While I was able to delete the photos of my family on the memory card on the camera I found, I was not able to do anything about the photos sent to this man's phone, and I have no idea what photos were taken on the other cameras or on other days. It was a major violation of mine and my children's sense of safety and privacy in our own backyard. My daughters are now old enough to go out there and explore on their own, something I did growing up in Vermont. I want them to feel comfortable that they are not being secretly watched in their own backyard. I believe regulations are needed on these devices for these devices to be used responsibly and to protect landowners' rights and the privacy of children and families. Thank you for your time and help with this matter.
Thank you. Thank you, Jessica. Are there any questions? Thank you very much. It's very helpful. I do have one question.
Sure.
You weren't able to get the images from was it 2 other cellular phones?
There were 2 other unmarked trail cameras on our property that we don't know what they took pictures of. Okay. And we weren't able to get the photos that were instantly texted to this person's phone.
And was it all 3 by one person, or there was more than one?
It was all one person. And he actually came back the next year and asked permission this time to put them up again, and we told him no.
All right. Senator Bruce.
Jessica, thank you for your testimony. Can I ask, when he came back the next year, was his explanation that the cameras were intended to watch wildlife on your property?
He just came back and asked permission to hunt out there, and we said no.
Oh, I see. All right, thank you.
Sure.
Thank you very much. Any other? Our next witness is Colonel Justin Stedman, Chief Warden of the Warden Service Division, Department of Fish and Wildlife. Colonel?
Full disclosure, Senator, I did not ask for that whole long thing. They could have just said Justin. It would have been
fine. We want to give you whatever's due.
I appreciate that very kindly.
And many people I've promoted and demoted in here with their titles, so it's helpful to read the title. So I don't make you a sergeant or a general.
I'll take Admiral General if you're handing out titles. Cover land and air. Thank you for the opportunity. A lot of my initial points that I want to talk about were covered by Judge Zone. I think he's smarter in terms of the law than I am, but it first read when I looked at this, I was concerned that I saw an exception for hunting. The way I read it, it says clearly the intent is to surveil people or property. And if I say I'm just putting it out there to look for deer or bear or moose or birds or any other animal, it seemed to be an exception to this that I don't know if it was intended, but that's what I saw. And I believe I heard that's what Judge Zone said. And also for consideration, the story you just heard is not unique. We get a lot of complaints, for lack of a better word, that are handled every year as best they can be. And something that may just want to be considered by this committee is to adopt, so Title 10, which I did not bring a printed copy of, I apologize, but 4713 is the statute that covers tree stands. And if I may, it is very brief. It's very plain language and it's very brief, and I wonder if it could be adopted to the purposes of this bill. It basically says, this is related to tree stands. It says, A, no person shall build, erect, maintain, use, or occupy a permanent or portable tree stand or ground blind for any purpose on any private land in Vermont without landowner permission. I wonder if something like that could be adopted and just replace the tree stand piece with a surveillance device or whatever you land on for a definition. Because it would seem to me to cover the crux of what I think this issue is, which is the specific surveillance of individuals, but it would also cover the story that you just heard. And to my mind, it's already a requirement. It has nothing to do with posted, unposted, has no bearing on any of that. You have to have landowner permission to put up a tree stand. You have to have landowner permission to put up a surveillance device. It does not seem unreasonable, and certainly with the technology today, folks who are in the hunting community there, Onyx is a very popular way. I mean, it is.
What was that?
Onyx is an app I can show you on my phone. It gives you the property boundaries in real time using satellites and GPS position. It'll tell you the tax data and all. It's all right on your phone.
So as in real time, as you're walking across the boundary?
Absolutely. And I live in an area where there's no cell service, so I preload a section of the map, and I don't know how, but it tracks me on. That's how I get to where I hunt. I just use Onyx and I walk, and I see it on my phone. I have no cell service, but I don't know if it's satellite, I don't know how it works. I'm not, like you, Senator, I might be a few years younger, but I don't know that I'm any more technically savvy. I grew up spending most of my time in the woods and didn't do a whole lot with electronics, but they work without cell coverage. So
I'm wondering if combining this section with the drones, so it's one big surveillance issue. Because I suspect people are surveilling others with drones as well as
very possible.
Trail cameras. So, linking the two and the exception for the law enforcement purposes, I think was a good point by Judge Zone. I don't want to upset something that's already been decided by the Supreme Court.
And I certainly appreciate that, and I appreciate you bringing that up, Senator, because we have had instances of graffiti, for lack of a better word, but people spray paint offensive terms and words on state signage at wildlife management areas, mainly because I think they're remote and there's not a lot of people around. And so we have certainly placed cameras on private property to surveil those, to see if we can catch people doing it. Right, and so we would certainly, we could always ask permission, but quite frankly, it's easier to be able to just put them up, and we don't want anybody to know they're there because we want to catch the people that are doing it, so.
Well, so that is both for law enforcement purposes and clearly not for the intent of surveilling the private property owners, given that it's facing in the opposite direction.
Right, absolutely.
So you said that this app has the ability to
I can show it. You want something?
I believe you. I guess I'm just confused about the process of posting and creating, does that have to be registered? How does the app know?
I believe it uses tax data from the towns, property tax records from the towns. So for example, if you don't mind, I'll just step over here real quick. It's cluttered because this is Montpelier, but if we go, so see all these red lines? These are all property boundaries, and you just click on it, and it tells you Vermont private land, it's the owner, it's the address of the owner, it's the acreage, and it highlights the piece of property, and it knows where you are.
That's
So,
wild.
I don't know if you want to see, you can pass the phone around if you want, Senator, but just, I mean, it's all,
Wow.
I'm gonna download that. It's great, it is a fee subscription, but it's not much, and it works. Yeah.
I don't know that.
But that's not the only app, there's a number of apps like that that are popular in the hunting community.
Maybe
for that very
we'll
purpose.
be able to tell us political party and other information where they voted on.
I think those apps exist too.
Separate from hunting.
Separate from, yeah. That's
Well,
very interesting, but it's not telling you whether or not that, it's telling you it's
Totally.
private, but not whether or not it's.
Correct. What we use it for and what most 99% of the hunters in Vermont are ethical and they use it, they say, hey, I want to go here. They find out who the property is and then they'll go talk to them.
Yeah.
And it's a tool and makes it very easy for when people say, oh, I don't know where I am. You got a cell phone? Yeah, we're not buying that now. You know exactly where you are. You ever heard of Onyx? Yeah, I have it. Great. They're even more trouble.
So then you would support this with a few revisions.
So, yes, and I spoke with Commissioner Herrick, and he is in agreement as well. I think the intent is good. I would quite honestly like to see it incorporate more of the language of the tree stand so that the wardens have the ability to do something about, because as you heard, and quite rightly so, the warden couldn't do anything, because it's not illegal. And it just
But
seems.
you at least were able to respond to the.
Yes. Yeah.
To the concern, which is positive, but yeah, you're right, there's nothing you could really do.
Right.
And the fact that the person came back next year to ask to be able to hunt there is kind of interesting.
And it seems, to my way of thinking, there's one thing to say, oh, I'm just walking across the property, what have you, but to go and physically deposit something or permanently leave something behind that is then recording what's going on there, it seems reasonable to me to say you have to have permission of the landlord.
I don't have trail cams, I don't think, on my property, but,
Not that you put there.
my experience is, I don't even have, I should have, because it's interesting to know when the bear comes across to go to the compost pile in my neighborhood. Which is a different issue, someday we'll deal with compost, and its side effects. Anyway, but I do have some visual concern about drones and their use in, neighborhood.
We have some great, we use a trail camera out in our back property, and we have some great pictures of a bobcat using a fence post like a cat eating its claws. It's really cool. They are very good. They have a lot of great purposes, for sure.
I know, my neighbor bought one of the best compost, things in the world, but didn't stop the bear.
Well, I've heard that part of the problem is that there's some overlap between the smartest bears and the
Smartest
smart humans.
compost.
Yeah.
Anyhow.
Bears
So
are
if you want the
great.
humans all to be able to get into it, some of the bears
I
will
don't think that
too.
problem's solved with this bill. Senator Bowles.
So this may be a question for Eric, and I'm thinking just in Chittenden County where there's really tight property, there aren't huge, if I install cameras on my property to surveil my property that inadvertently are also surveilling my neighbor's property, is that going to be a problem
Good question.
under this bill? Because it's where you're hunting, I don't think it would be a problem because neighbors are miles apart, but I live in a townhouse. So I'm an end unit, so it actually doesn't, but my driveway cam, for example, does probably surveil my neighbor's driveway. And I'm wondering if we're gonna create a problem there.
Eric?
I don't know.
I think the intent language
Okay,
keeps you from inadvertent
okay.
use of someone else's property. The intent is to surveil a person on their property. I think that's what the language provides now, at least in the draft that you were most recently been looking at.
Yeah, I just want to make sure if we make any language changes that just, again, the county I live in, there's often a lot of really compact properties that we're not inadvertently sweeping in someone whose intent is to know what's happening on their property.
And I think one way of determining intent might be in the specific fact pattern, somebody's at the edge of their property and they've got the camera facing out. At that point, their intent is not to capture their own property, to surveil the neighbor's property. So it seems like we could, there's always going to be trouble finding intent and proving intent, but it seems like these cameras provide a lot of evidence. For instance, on the example we were talking about with the witness, I got a text saying that she told me on the memory card was a picture of the guy setting up the camera, and he was checking his phone for location. So capturing intent on the camera. I'm thinking of incidents where people are setting up cameras. For instance, there was a guy at UVM Medical Center who set up a camera in a changing room for his colleagues to be captured. And he was captured on the card itself. So this high tech produces evidence of intent even as it's being used as a weapon. So.
And this individual may not be the only one who's using a trail camera in that area too.
Senator Ruth, is your suggestion putting in language that clarifies that a camera placed at the edge of a property?
No,
I was gonna say, I think they're challenging.
I was just saying in terms of a prosecutor deciding or a law enforcement officer deciding, that might be a factor.
The intent to conduct surveillance. That's the key word right there.
Yeah, I just recognize that the situations you are describing out in more rural areas are going to be very different from the situations in much more densely packed areas. And certainly, you know, my intent of putting cameras up was to surveil, if you will, my property, given that I had experienced some threats.
We've got about 6 minutes. Is anybody else that'd like to comment on this section? This proposal? Colonel, thank you so much.
Thanks, sir. Appreciate it. Thank you.
Thank you. Thank you. And thank you for all you guys do.
Thank you very much, appreciate it. Just so you know, we do have a drone hunt, that you can't hunt with drones either, just so you know.
Also, thanks for that app. I sent it to my brother. I think
Oh, you're
he'll
welcome.
like
It is very handy.
Onyx?
Onyx,
On
yes, I can show it
X,
to you if you want.
not Onyx like
Sure,
color
Got it.
or gem.
Take up your time.
Is it a mineral? Onyx? What is onyx? Stone?
Probably, I think it's.
5 minutes.
Yeah.
And then it just, like I said.
I'm not-
What kind of?
I mean, I can Google it, but I'm not whatever
We were gonna take up.
scientist studies rocks. That's not what my science degree is.
It's really handy. And most, I think that's one of the most popular, but there's more out there.
The gemstone.
Thanks. Yeah, you're welcome.
Yeah.
It's an oxide mineral-based gemstone. So
Well,
I think we
knew
were all
that.
right.
I knew it was an oxide-based mineral.
Yeah, well, I'll email
Go.
in case you want to review it.
Yeah.
Closely related to agate, which is another oxide-based mineral.
So, I thought we'd take a couple of minutes to look at, miscellaneous judiciary bill, H 878. There seems to be an interest to add the so-called Baruch Amendment and the Attorney General's Amendment. So I would keep them separate, although my intent would be to have this part of the drone, to couple this with a drone.
You can put it next to it. The reason, it wouldn't really work to fold it into the drone statute.
Okay.
The drone statute, the amendment is within the drone chapter, it's in Title 20. It's very different than,
Okay.
and it also involves things like 100 feet flying altitude, that sort of thing that aren't related to this. So it would be quite tricky.
Well, on the drone specifically, I'd like it 75 feet.
Is that a federal standard, 100 feet?
No, well, no, the federal standard is 400, but the conversation I had with the FAA about it, that the lower you get, lower is no problem. The closer you get to 400, the more likely you're gonna conflict with federal aviation law. So, so you wanna change that on page 45, Senator
Yeah.
Sears? You want it to be less than 75 feet, not less than 100?
Yeah.
So the prohibition only applies, so in other words, the person flew at 100, it wouldn't be prohibited anymore.
No, I'm just curious, is there, I guess, curious as to why, and if there's some sort of big difference that happens within that 25 feet.
I don't know.
Definitive answer.
Forget it.
Okay.
All right, it's fine. Leave it at 100 feet.
I was just curious, but yeah.
All right, so,
Yeah, the AG language is in here for the moment, and I understand there's gonna be more testimony about that next week. From what you said earlier, the Senator Bruce amendment regarding real property is in here as well. Those are all
with
highlighted.
some changes to Senator Baruch's language
Yeah.
on, the exemption, or
Yep,
exception.
law
for
enforcement officer, yep.
And do we want to reword the terms, secretly and spying?
As I mentioned, that language comes from the voyeurism statute, that's where that's
So,
from, but
It's been used,
yes.
so I guess I would say that that's okay. As long as the courts have already used that language.
Yep, it's been in the voyeurism statute for quite some time. There was a question about whether, I think Judge Zoney was raising the idea of whether, the person, should it be a person? Should it be just to conduct surveillance on any other person as opposed to a particular person? So you may want to change that.
Yeah, I
To
thought
a
that was-
person.
Yes, I think we should change that.
And then I hadn't had a chance to look at it, but I think he was gonna email, well.
Yeah.
Right.
Senator Bohowski and then Senator Hashim.
Thank you. I found Judge Zonet's language around surveillance device to be a lot clearer and more understandable. I know that secretly and spying are in our voyeurism statute, but I think we have a lot of statutes, older statutes that are somewhat harder to understand and less clear. So like, I know they've used it, but I think if we have the ability to create more clarity about what we mean, it's not a bad idea to do it. I don't feel so strongly in one way or the other that I'm gonna hold things up if we decide not to go that way. But I did just wanna say, I thought Judge Zonet's language was much clearer.
Well, I can put it in there and then you can just look at it.
Yeah, why don't we do that for
Yeah.
next week?
Right.
Okay, can we go to, a section that I proposed adding? I believe it is on page. Where is the section on,
Life estate deeds?
life estate deed?
Yes, that begins on page 48. Well, 47 technically, but the new language starts on page 48. And this, sorry, did you want to go first? Something to say, Senator?
No, I think I'd let you go ahead. I've talked to most people, both Senator Baruch, Senator Cummings, as well as Senator or Representative Lalonde. They're concerned with how the tax department has interpreted what we did in the life estate deed bill. It's that simple. They've interpreted it to mean the tax is due at the time you sign the life estate deed, not at the time you transfer the property. And there's an 8-year, for some reason, there's an 8-year window that they added to the rule where you can get a refund if the person decides not to deed the house for whatever reason. But the whole idea behind it, as I understood it, was to avoid probate and to allow somebody to transfer property upon their death, not upon, So in my case, I'm still living in the house, it's my house. It's not the person that I'm giving it to's house until I die, and then it would be his house if I follow through. But I could decide to move to Bon Air and sell the house and go somewhere, and then he's already paid the tax on it. Then he's gotta go through and try to get a refund from the Vermont Tax Department. So this tries to solve that problem.
Yes, exactly. And I've worked on this language quite a bit with some real estate practitioners in the Vermont Bar Association. So I've been working on this language quite a bit. And I think we've come up with a process that will address one of the major concerns that the tax department had. And what they were, I think, well, one of the things they were most worried about was that, when you execute the deed in the first place, well, how are they going to know when the person passes away later on? So how are we going to know that the tax is going to be due? So the process that you see set up here is that when you do the deed in the beginning, like say you had just done yours recently, you file in the tax records notice that you did that. And so that property transfer tax will be due later on down the line. Then you have permission from either person, the landowner, or their person's attorney conducting a title search to be able to ask the tax department, hey, because they'll see that document in the land records. They'll say, hey, was this tax ever paid? Tax answers yes or no, and then they'll know whether or not it has to be paid later on in the future when the person passes. So it seems to work for the real estate bar.
And the deed would not clear title if it hadn't been paid, right?
Right, then there would be a cloud on title. If it was never paid, there would be a cloud on title. So if a person tried to sell it later on, it would be challenging to be able to certify title to the purchase.
Anybody have any comment on this section?
No, it makes sense to me.
The bankers okay with that?
Yep, Chris Delia, President of Vermont Bankers Association. I've been in the email chain that Eric and others have been involved with, and they've come up with a very nuanced solution to address what you've raised, Senator.
Thank you. Okay, so everybody okay with that? Mm-hmm. So we'll leave miscellaneous, yes, Senator Machine.
Yep, Eric, I wanted to ask about, just wanted to clarify something for page 9, lines 6 through 8.
Yes, I wanted to mention that one too.
Is there any, I see the notwithstanding language now, but is there any confrontation clause issue with that?
Yes, and so what's going on here is that this is the one, Senator, you may recall, that we were asked about by the department on. So this is the piece that's regarding the competency evaluation that's connected to the bill, the legislation you passed over the last couple of years. And so this has to do with that. You may remember that there's a competency proceeding that will take place when the defendant's competency is challenged. That report is made by a psychiatrist, or now
What page are we on?
Page 9. Remember, the report can be done either by a psychiatrist or now, because of the new statute that you passed, by a psychotherapist who has the right kind of forensic training. A question came up as a result of a decision that Judge Pacht just issued within the last week. Remember that? And that decision said, well, on the basis of the current Vermont Criminal Rules of Procedure and the Confrontation Clause, that whether it be psychiatrist or trained psychotherapist, either way, that person has to testify in person rather than remotely because of both the rules and the Confrontation Clause. So the way it's written to address that is, first clause you just mentioned, Senator Hashim, notwithstanding any provision of law or rule to the contrary. So that will override whatever criminal rules are. With respect to the Confrontation Clause, you obviously can't override the Confrontation Clause by legislation. That generally requires in-person, face-to-face ability of the defendant to confront their accuser or other witnesses against them. I researched this issue extensively, though, and with respect to this the courts are very consistent in saying that the Confrontation Clause is a trial right, applies at trial. And whether it applies to other pre-trial proceedings, other proceedings outside of trial, is not clear. And in particular, with respect to pretrial competency hearings, there's several cases on this, and they all quite clearly say that it is unclear whether the Confrontation Clause applies to pretrial competency hearings. There's a lead case on that from the 7th Circuit, Southern District of New York case, District of Maine, a bunch of federal cases all say this. It's not clear, but they do go on to say, well, even though it's not clear, we'll assume for the purposes of this decision that it does apply. And since the person has a right in those particular instances, the person had a right to cross-examine the person, then they were going to say that it would have been satisfied anyway. So in this particular case, think about it, the person is appearing remotely, there's an opportunity to cross-examine the person. So. at
So
least under
these
that
are
analysis-
pre-trial hearings though, right?
Correct.
Well, this is all to,
The competencies before the trial even takes place, to establish competency.
this is kind of an immediate problem which undoes, I mean, to even get psychologists or psychiatrists in to schedule them into court is difficult.
Oh, yeah,
Having them required to be in person.
I don't disagree at all.
So try
I
to
also
get
just
it
want to
done.
make sure that it's not, blatant or, facial, obvious violation of the confrontation clause, but it's a pre-trial hearing. So,
And the cases that have looked at it, and I agree with you, I was gonna wrap up by saying exactly that, that doesn't mean that it's fully finally resolved issue. I think it's an issue, someone might litigate it. But in fact, Judge Park, his decision, went the other way, although it didn't refer to any of these cases. But these cases that I found quite clearly said it's unresolved whether the clause applies.
really
And so I think it's gonna be
Want
up
to
to.
move to the other two bills, Michelle's here.
Yep.
And we'll take up later on.
So we'll come back to this.
Oh, yeah,
Okay.
we'll head back to this issue, or this bill shortly. So Michelle, now we've got, you took all those bills again.
I did.
Now you gotta start over. You didn't-
I don't think
you
I let
didn't
you take
trust us
mine.
with the bills.
Well,
Alright, well, here's the draft.
I think we've all proven at least once today to be bad committee members, so.
what did I do?
Lost your,
Oh, yeah,
you lost one of your bills.
I did. Wasn't my bill. I know where it is.
This is your folder.
It's just not with me.
It's just not here.
Y'all are lucky to have a Ben.
Yeah.
We are
I
very
need a
lucky to have a
Ben.
Ben.
Everybody needs a Ben. What are you gonna do? This is the ceiling bill first, which turns out to be down to a study that we discussed.
So I don't think I actually gave you my bills back.
Yes.
And I didn't lose them.
You let me know when you're ready.
I'm ready.
Okay, so everybody should have a copy of draft 2.1, strike all amendment to H 655. And so there are no changes to section 1, which is the look at the ceiling, length of time, other states, et cetera, by the Joint Legislative Justice Oversight Committee. On page 2, section 2, on petitionless ceiling, you'll see on lines 4 and 5 and 6, I just added that the Chief Superior Judge, in consultation with the usual folks, shall examine the laws and procedures of other states regarding petitionless sealing of criminal history records and shall submit to the House. So I just added that in there, that they're supposed to be kind of taking a look at the way that other states approach the issue for petitionless sealing. And then you'll see on lines 12 through 14, I just retitled the bill, "An Act Relating to Studies of Policies and Procedures Regarding the Sealing of Criminal History Records," to more accurately reflect the new content.
And then it's effective on passage.
Correct.
Is there any discussion? It'd be nice if we had all 5 members.
Well, so Senator Booth will be here in a few minutes, and I just texted Senator Norris. Do you want to go over the other bill while?
Yeah, why don't we go over the other bill?
Just gonna hand you guys the new draft rather than your folders.
Okay,
I think that's a little easier.
well, I'll need my food. I wanted to first this bill.
Sounds good.
Oh, very first one we did.
I just have to reorient myself.
Senator Norris's whole family in here.
So first amendment on, this is H 173.
And you should have draft 2.1 for this new amendment. So there's 2 instances of amendment. Your second instance of amendment was what I already walked you through when we discussed earlier this morning. And then in that second amendment, second instance, you had removed subsection A out of the purpose. And so now I've just reproduced it in a new section 1 for a legislative finding.
Okay. So even though we're striking out A and putting it into finding, we strike it out in the this amendment.
in the purpose section.
And then
Yep,
the rest of the bill is as passed by the House.
correct.
We usually do strike all, so it's gonna be,
I could do it for you as a strike all. I just sometimes, you know, if you prefer it in that form, but because you weren't changing most of the bill, it's just,
I think strike alls are easier to report. Personally.
You're recording it, so I have no opinion.
No, okay.
you want me to do it as a strike?
No, this is fine.
I can, how about, well, I can
No, it's-
I can do a dummy strike all for, and I don't mean.
Never heard of a dummy strike.
That's no reflection on you, but I just mean like I can do a mock-up
I
of
need
one
the
if
file.
it's easier for
That's
you
all.
to read
Yeah,
on the
no, that's
floor.
fine. Why don't you just give me a clean version, I'll take it up as is.
Okay.
We'll try to get the votes from Senator Baruch and Senator
I can go
Norris.
get Bruce, Senator Bruce right now, and then. Who
Yeah,
knows?
Senator Norris is with his family.
Yeah, I don't think I.
Well, we can count him as a 0. A 1, I mean, it could be 4-0-1.
Yeah.
He can change, we have time to get him to change. Yeah, leave this as it is, I just need a clean copy of it to take upstairs. Because there is an amendment.
And I do realize it's, you know, it's always easier with a strike all, but sometimes if you do a strike all, it seems to the other body like you changed a whole bunch when you actually didn't. And so.
Well, we really just took out one section and changed.
And added one word.
One word.
Right.
2 words with intent. So, is there any discussion in the room from any of the advocates who want to speak to? So, we're just waiting for another member to vote.
Alright, found one.
All right, well, Senator Norris is not here, but, so we're gonna start with H 173, the coercive.
Alright.
Coercive control.
Coercive
Wrong
control
bill.
bill, thank
Oh.
you.
Wrong bill. It's not
It's
coercive control.
manipulation.
Manipulating.
Oh, right, that was the other, that's
This is
mine.
manipulating for the purpose of grooming.
Yes, coercive control is
But we
mine.
don't use the word grooming for some reason. Anyway, the changes are in front of us in draft 2.1. We've changed, we've added findings that were part of the purpose in the House version. We add the words with intent to the purpose section in section 2, the new section 2, so that it's clear that it was within the intent of sexual acts, etc., not intent to, it has to add that intent. So with that, I will assume that somebody has moved to report the bill favorably. Senator Baruch did. Thank you, Senator.
Second.
Is there any further discussion? And we already asked for discussion in the audience. There was none. So Ben, if you would call the roll, please.
Senator Bruce,
Yes.
Senator Norris, Senator Mahovsky,
Yes.
Senator Sheen,
Yes.
Senator Sears,
Yes,
4-0-1.
I will report the bill.
And then both of these have been edited, so they're,
They are
kind of-
clean?
yeah, so you can take them.
Okay, if you just make me a clean copy, I can take
Yep,
that.
I will put together a file before the floor.
The next bill is H 655, which was a very expansive ceiling bill, which we have
Turned into a study.
changed to a study. And basically, we can't come to an agreement with practitioners on who gets the record and how long they get them. And what they can do with it. So, I think we've kicked this horse around the park long enough. I'm disappointed we didn't get where I wanted to be. There's always next year, as they say in Red Sox land.
I think it was wait until next year.
Yeah.
Yeah.
Wait a minute. So, the motion to report favorably draft 2.1.
So moved.
Senator Wahowski has moved to report favorably H 655 as drafted in 2.1, which is a strike off. Further discussion from anybody? Any on the committee? So Ben, could you please call the roll?
Senator Booth,
Yes.
Senator Norris, Senator Wahowski,
Yes.
Senator Sheep,
Yes.
and Senator Sears.
Yeah, yes.
401.
Who would like to? All right. I don't mind.
I would do it, but I already have a really big.
Yeah, you have a big bill. I've got this little thing that can just be embarrassed of.
Michelle, is 2.1 clean as well?
Yes, they both are. Senator Sears, I'll do a section by section for you on 173. Do you want one on 655 or?
No,
Okay,
no, I know what the,
The retail tax one, or was that Eric?
that's Eric.
That's Eric.
I mean, until you, I know everything. I know all I need to know
I know you do.
about this issue,
Yes.
Just wanted to check.
but thank you.
Sure.
But